All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here, coming at you live. 540-0580. Talk line number. Call in with your legal questions. As you know, I come on here every week from 1 to 3 and answer your legal questions. But today, from 2 to 3 p.m., we're going to have a very special guest. We're going to have David Nesbitt, along with John Reese and Paula White. And they're going to be here to talk about elder law and surrounding issues. So this is your big chance from 2 to 3 p.m. today. So stay tuned. And, of course, if you know anybody who's, say, 40 or over, we'll start there. Or, heck, anybody that's in their 30s but has a parent, could be anybody, they really should tune in at 2 o'clock. So pass the word and let them know this is going to be our elder law special. And, of course, if you have questions about elder law, hold them till 2 o'clock, and we'll get them answered by the experts there. Of course, I'm always fair to chime in as well, and I might do that myself. But today we've got some people who that's kind of their primary practice, so I thought we'd have a good time learning from them. Actually, I may have shared this with you guys before, but there was a study done not too long ago where they took actual verdicts that juries came up with, and they took a personal injury attorney, someone who did personal injury work for a living, gave them a fact pattern that the jury had been presented with, and asked them to estimate the value the jury would have awarded. And they could get within about 50% of the actual value on average, meaning that each personal injury attorney acting alone could get within about 50% of what the jury actually gave. But that's still a huge margin of error. So then they gave the same problem to 2 attorneys and had the 2 attorneys talk it over and then mutually reach a value that they could both agree on. And they found that there they were within 15% of the actual jury verdict. And it's one of the empirical studies that proves that the more lawyers you have, the better you'll do, hence O.J.'s verdict. 540-0580. Joseph, you're on the air.
Thanks for taking my call, Carl. I got a question regarding a will. I have a will. It's not that old. It's just a simple will, not very long. It says I'm a single individual that all my assets are divided among my 4 children. Mm-hmm. My question is, my one child's going to buy a house. I'm giving her a sizable down payment. Can I do an addendum on my will, just saying that, this child gets this amount, the money I'm giving her, less this amount of money? Or do you have to do a whole will all over?
Well, in the old days we did what they called a codicil, and that's just fancy for addendum to the will. And you can do a codicil. The modern practice, and in the old days when codicils were invented, writing something down was a big deal and making copies of it was a big deal. So it made sense to, rather than rewrite the entire will from scratch, just add a new little paragraph saying, strike paragraph 12 and replace it with this. And we call that a codicil.
Oh, okay.
In the modern era, it's just as easy to create a new will on a word processor for the most part as it is to create a codicil.
Well, that's probably true.
So it seems like the codicil's fallen out of favor. Not that it can't be done, and not that it's not perfectly legal. And yes, you can do an addendum. But if you're going to do a codicil, it has to be done with the same formality as the will itself. I mean, that's a general rule.
Yeah. Do you get 2 people to initial that page?
Yeah, you want witnesses and the whole 9 yards. We do a free will at our office. If you call in, they'll send you the free will kit, and you can just get it redone that way.
Well, maybe I'll do it then. It's probably better. It's not much that I was going to add. It was just a thing that my daughter... Just
that I gave, I want them to split these shares, but less X dollars because daughter A got a down payment on their house.
Yeah, I want to help them while they need it instead of waiting till I die. So
right.
I'll help them. But in fairness to the other kids, she shouldn't get a full amount. Okay. Well, thank you very much, Carl. Appreciate it.
All right. No problem. Take care.
Bye-bye now.
540-0580. Of course, I want to remind you, September 4th at 7 p.m., I will be giving a lecture on gun laws and gun rights at the Harrisburg Hunters and Anglers. So if you want more information on that, of course, we'll put it up on the Rominger Law Office Facebook and my Facebook. And we'll put a little thing on our website, romingerlaw.com. It's already there? Oh, it's already there. Well, of course, it's already there. What do I know? And, of course, you can still get your free coffee mugs at the Carlisle Bakery at 35 South Hanover Street, Carlisle, Pennsylvania. When you stop in and order a cup of coffee, just ask for a Rominger & Associates mugs, and it's yours to keep. Keeps hot things hot and cold things cold, especially beer. 540-0580. Joan, you're on the air.
Carl, thanks for taking my call.
No problem.
I have a quick question about settling an estate. My oldest son is my executor, and my question is, if he settles whatever debts I owe, mortgage, car, credit cards, and the estate is out of money, but there's still money due, is my oldest son personally responsible?
Generally,
for the
no.
rest? Okay.
He just needs to be careful when he's doing things not to obligate himself. And so, sometimes I say tricky people, but sometimes, the undertaker says, well, you're going to be the responsible family member, so you sign here. The money will come out of the estate, but by signing the undertaker's papers, for instance, you're obligating yourself as well. Some nursing homes will tell you, are you going to be mom's official representative here at the nursing home? And you go, oh, yeah, I want to be. And they give you a pile of paperwork to sign. Well, somewhere in there is a sheet that says you personally guarantee mom's bill.
I see.
I, in fact, can tell you this story that when my grandmother was going into assisted living and I met with the people and I was down there moving her in, they, of course, did the thing. Here's the packet of information. I signed everything except that page. And they're like, well, you really should sign this page. And I'm like, well, this says I'm going to be a personal guarantor. And they're like, well, you don't want us to kick her out on her ear if she runs out of money, do you? And I'm like, you're not going to do that. I already know that.
Right.
But I'm not going to guarantee the bill.
Would Medicaid take over
Right.
usually at that point if she ran out of money?
Right. In that particular situation, she wasn't going to literally get kicked out, but I knew they were just trying to make sure somebody else was on the hook.
I see.
And they didn't like me for some reason.
Okay. So, like credit card debt especially,
No.
I was worried about that.
No.
Okay.
No. And my advice is charge them up.
Okay. So would a spouse be liable, but not a son or daughter?
A spouse could be liable for some of the debts. Now, there's a statute out there that seems to say that people can be liable for the debts of others. And I think at 2 o'clock when we get Dave Nesbitt in here, I want to ask him about that and see what the status of it is. There's been a lot of effort to repeal it, but there's a statute out there that basically says that kids are responsible for their parents and vice versa, but you never see it applied in reality.
Okay.
All right?
All right. Thanks very much. I'll be listening.
All right. Thanks.
Bye.
540-0580. Jack, what's going on?
I have a situation where PP&L entered one of my properties. They knocked on the door, told the tenants that I told them to call, and they entered the property, said that they needed to do a check of the system based on an Act 54 investigation.
Okay.
There was no complaint filed. I don't understand how a utility can enter a property without permission.
I have no idea.
I mean, I know city codes can't enter a property under any circumstances.
Well, they got to get a warrant. Utility, I don't think, has the ability to enter per se. Did the tenant let them in?
Well, but they told them that the landlord called and they were doing an investigation. I mean, they flat out lied to them and said that the landlord sent them. I mean, the tenant called me right away.
Right.
PP&L that they were absolutely in violation, but they're trying to do all kind of crazy stuff and push it, just doing ridiculous stuff.
Yeah, I don't know. I have no idea on the answer to that. I mean, obviously, if they lied to gain entry, that's technically a trespass.
It's definitely a trespass. There's no doubt in my mind that there's a trespass.
Now, the question is whether it's a innocent trespass or not, or whether it's a harmless trespass. And so a harmless trespass is one where ultimately there's really no damage to you because of the trespass, and realistically they could have got in somehow, some other way eventually anyhow. So there's no change in your status or damages that flow naturally from it. On the other hand, an innocent trespass might be where simply the guy on the street got the bad information. Maybe they did have a tenant complaint or a landlord call in for another property, and the guy was confused on who's on what list for what purpose. So he didn't willfully lie; he just was mistaken. But here's the question: I mean, what happened? They come on the property and they did what?
Well, they went through the whole unit.
And
they went through both units, knocked on both doors, went through both units, plugged outlet testers in. I mean, basically, falsely identified. They were there to check a meter is what they were there for.
Okay.
Not to enter the property. PP&L only has the rights to public easeway for what their equipment is. Uh-huh. Anything from that point of attachment down belongs to the property owner except for the meter itself.
So what were they trying to understand what they were trying to do?
Well,
make sure the meter was being run properly?
they're trying to say that there was an Act 54 violation. Now, I don't know if you're familiar with Act 54. It's a foreign load. It's what they classify it as. In this particular situation, they said that the hallway light, there was a hallway light that was on the first floor tenants, which was absolutely false, and an outside light. They said there was 2 light bulbs.
Okay.
There weren't even, they can't even say there was the presence of a foreign load, no matter what the circumstances were, because there weren't even light bulbs screwed in.
So what they're trying to say is what? You're billing one of the tenants for something that should be for the common area?
That's what they're trying to say, right, exactly. So what they did is, the PUC, nobody will give me information on Act 54. It's very, very hard for me to gain any information on Act 54. I've done some of my own research, and they have said that it specifies in there from the time of finding that the landlord or property owner is responsible for paying the utility of that whatever unit it is until a time that it is fixed.
Right. All right. I gotta go to break. Can you hold with me?
Sure.
540-0580. Hey, welcome back. Carl Rominger here. Okay. Have I still got him here? Jack, you still here?
Yes. Yeah.
Okay. I was doing a little research during the break here. Basically, it looks like there's a regulation 66 PACSA 1529.1, which was part of the Landlord Tenant Act revisions in 1993, 54 of 93. Basically, it says once any common area is found, it has to put the entire electric bill in the landlord's name if any portion of the unit is being subject to a foreign load, such as anything in a common area.
Right.
I think one way to you could do that by lease. You could circumscribe your lease a little bit and change it around and say that you're responsible for the following light bulbs as well.
Well, the thing is, there was no foreign load. I mean, they're not even. I had even asked the 2 PP&L reps,
right?
What their qualifications were, and neither one of them has any past electrical background. It's just all they do is pull meters, and I mean, I'm not even sure they can read a tester. I happen to be a master electrician, so a licensed master electrician. The reality of it is, they're trying to make me responsible for a $700 electric bill for basically what would amount to about 15 minutes from the time the tenant called me till I got there and signed that there was no foreign load, that they did not have. The problem I have here is the trespassing, because absolutely, positively, no one can enter your property without prior permission. If a tenant would have complained and the tenant left them in, then they have a right to go into, say, unit number 1.
Right.
If the second floor tenant never called them, they wouldn't have a right to go into the second floor. They would absolutely have to call the owner of the property up.
Wait. No. They have the absolute right if the tenant invites them in or allows them in, right? Because the tenant owns that leasehold at that point. So if I'm your tenant, I can say, come on in, power company. Right?
Well, but not if they're there telling you.
Well, no. I mean, now that's an interesting question. They may have gotten permission from the tenant through deceit, right?
Okay.
But is that your issue or is that the tenant's issue?
Well, the tenant called me in a panic.
I understand.
They weren't left a choice.
Right, but you see what I'm saying is
they had to leave them in if there was an investigation. Yeah, and I understand what you're trying to say, but the reality of it is, PP&L, if they're going to do anything like that, the city has to call me and make arrangements.
I know. I'm not saying they did. I'm not saying
they have code enforcement.
I'm not saying they did right. I'm just questioning what your remedy is. I mean, maybe an order, a letter to PP&L saying don't come on property again without my permission. But what they're going to say is, hey, the tenant let us on. So the tenant's the one who's going to have to complain that they were let on false pretense, right? Right.
Okay. I filed a complaint to the PUC.
Yeah.
And, of course, now it's got to go formal. Because the PUC, which is supposed to stand for Public Utility Commission, should just be the Utility Commission because...
Right, PUC, PPL, same people, right?
Well, yeah, because they're saying that they don't care if it was found illegally or not.
Right,
I called
right.
the district attorney's office. First, I called the attorney general. The attorney general told me to call the district attorney. They felt that was the district attorney said that they would prefer that I try to remedy it through the try with PP&L and then go from PP&L to the PUC,
right?
Because that's the proper channel to go with. The problem I have is that I feel that there's absolutely some sort of criminal.
Oh, I understand how you feel. My question is whether you have any real remedy. But hey, keep going through the PUC. It's very interesting, and I think we learned something new today. All right.
Okay. Thank you.
All right, Jack. Very interesting. Bill, you want to know about autopsies? Hey, Bill.
How you doing, Carl? I enjoy your show. I did. This came up periodically, and now I've read in the paper today in Meadville, a young lady was killed while she was lying in bed at 10:30 p.m., and they're going to perform an autopsy on her. Why do they perform autopsies on people who are victims of a crime or accident when they are not involved in anything illicit, so to speak?
Well, here's the answer. Whenever somebody is... There's different reasons for autopsies. So usually autopsies are done whenever there's a suspicious death. So if you're 88 years old and you pass away in your sleep, there's probably not going to be an autopsy, okay?
Right.
On the other hand, if you're 35 and you fall over dead at the basketball game, they're probably going to do an autopsy.
Yeah, well, this gal was 51 years old, Carol Lee Ramey from the Meadville area, and they're doing an autopsy on her, and I can't understand that.
Well, maybe there was some other thing that the police found.
It must be. It's not printed in the paper. But is it common to do an autopsy, or does it have to have a reason to do it?
They're done commonly, but here's the thing. They're very expensive to do.
I understand that.
So with that in mind, you tend not to do them unless you have some hook or basis to think there might be a reason, or there might have been some medical misadventure, let's say, at the hospital, or you think that there was some foul play, or again, the person just falls in a category of person you don't usually find dead at that age. 51, I mean, that's still a little young to just fall over dead.
Correct, and she was lying in bed. I assume she was, unless she was part of the a situation where this guy ran into the building with his truck, and they were both involved in some kind of illicit affair of some sort.
Is that? I mean, if her car was if a vehicle had struck the building, it
did.
They may be investigating whether a crime occurred or not. So if the guy was DUI, later they're going to have to prove that him striking the building caused her death. Because if I was his attorney and they didn't show up with an autopsy, I'd just say, "Hey, judge, I think she might have been already dead when he hit the building." Okay,
all right. So they have to find that she was a victim of this accident or incident that occurred.
If they're going to punish him for it, if they find criminal activity.
Okay, that's understandable. I thank you very much.
All right, no problem.
Okay.
540-058. I got people. Is he calling from Meadville or just following Meadville? What's going on up there? I spent a lot of time at Allegheny College, and my brother lives up there, so little hometown connection. Chase.
Yes.
How are you?
All right. How are you doing?
Good, man. What's going on?
No, I spoke to you last week about the denial of the concealed weapons permit, and I was just wondering, you had said, was there any 304 or 302, and there was not. There was a Section 201, which is voluntary. Is that something, now I got a paper to I guess, fight the denial, but it says if you sign this, they get released to the documents, and I don't really think. My question is, am I obligated to give them that, or can I say, hey, wait a minute, I don't feel this is justified here because there's no 302, no 304,
Well, so, I think you're going to have to, if you want to fight it, give them access to it.
Okay, now there wasn't any transparency, exactly on. I just had went and checked the records because the way they stated it was for undisclosed reasons you were denied. So I don't really actually know the reason of denial, but
right.
Based off of talking to you last week, I figured I better check into it and. So should I get a reasoning before I even sign anything? I mean, this is something I'm not...
Yeah, it might be a bad idea to get their reasoning first, but...
Okay, and this was something, I guess it's PICS, P-I-C...
Pennsylvania Instant Check System.
Yeah, I mean, that's like a computer kind of thing, right? So a red flag must have flew up somewhere.
Right, and with that, a lot of times a quick hand search reverses it.
Okay. All right. I mean, now, my another question I would have is, like, if I would decide to go into this, I mean, would they?
I don't
could
think
I potentially?
By the way, I don't think a 201. I don't think a 201 bans you from having firearms.
No, and that's my thing is I have firearms, and I'm afraid if I pursue this or fight it, they're going to look and say, well, you know, because it's not who the person is. You know, this was 12 years ago. It's not who the person is now. It's who they were then.
The Mental Health Procedure Act, which is Act 77 of 1976, says people who were involuntary committed under 302, 303, or 304. For can't have a firearm, and a 302 remains for the rest of your life unless you get it expunged. But I would think a 301 is not going to do that.
Yeah,
or 201 rather.
Yeah. I just that's what I mean. I don't understand. I mean, I was sold a handgun. I was sold other firearms, so there's obviously nothing there. But I just don't understand the denial is my problem.
Well, they may just show a 201, and but it may just flag as a Mental Health Act filing, and maybe once you get them to look at it, my advice is I would challenge it, and you're probably going to be fine.
Okay. See, I was just afraid, you know, because I had gotten a copy of these papers, and, you know, I was kind of forced into volunteering and, you know, demonized by someone in my family.
Well, a lot of times you're given an option to 201 yourself before you're 302'd.
Okay, so yeah, and that was you know, so it's not really what my opinion was on the situation. It was what's in black and white of the other person.
Exactly. Well, what's in black, right?
So
but
when they see that, they're like, "Oh, this guy is like."
Yeah,
you know.
But that's not a grounds. I mean, it has to be an actual for the Pennsylvania Instant Check System. It's not somebody's subjective. It's what it says on paper in terms of the actual code number. So if you're 302, they're not going to issue it.
Okay.
If you're not 302, then they can't stop you, even if it was the 302 was denied and, you know, some family members said all kinds of bizarre things. Here, you voluntarily committed, so you're probably fine. As I read the law, 201 is not a per se non-issue. And it wouldn't surprise me if they just saw something under the Mental Health Procedures Act and flagged you, but didn't bother to look up which subsection it was.
Okay, all right. Thank you very much. I appreciate it.
All right, Chase, go get it.
Yep. Bye-bye.
540-0580. See you after the break. Hey, welcome back. Carl Rominger here, 540-0580. Answering your legal questions. And, of course, don't forget we're going to have Dave Nesbitt and crew on with Elder Law here at 2 o'clock. And I've actually got them in studio a little early, so we may do a sneak preview of that in a little bit. Corey, you're on the air.
Hey, Carl. Thanks for taking my call.
Not a problem.
My question for you today has to do with getting paid for a vacation day. Back in April, my employer sent around a new copy of the handbook, and everybody had to sign a paper stating that you acknowledged that you got a copy of the handbook.
Okay.
Everything was dated April 2012. Now, one of the updates in the handbook was it used to be that you had to work there for 7 years to get paid 3 weeks vacation. Now, the new update is you only have to work there 5 years to get 3 weeks.
Okay.
Now, back in February would have been my 5-year anniversary, and I talked with my immediate supervisor about this just to confirm, and he said, yeah, you should be getting 3 weeks vacation this year.
Right.
So I've gone and used up 2 weeks. Last week I was really sick one day, and I thought, well, I have another week vacation left yet.
I think I know where this is going.
I'm going to, let me take off work because I'll get paid for it anyway. So when I get back to work, I'm told, no, they don't want to pay me for that day off now because they said that the new handbook doesn't take effect until 2013. And I'm like, now, wait a second. It didn't say that anywhere.
Right.
It has the date of April 2012 all over. Every page of the handbook says April 2012. And then my other point is, so what are you doing? Hiring people this year and giving them a copy of the handbook and telling them, well, this doesn't go into effect until January of 2013.
Right. And the handbook is binding, so theoretically you're owed that vacation. I don't know what your remedy is, though. I wouldn't know what you could do. I mean, I guess if you said I quit because they're not going to give me the vacation that they promised me, you might be able to survive and get unemployment. Who can you mediate with at the company? Anybody?
Well, I don't know. I suppose I could sit down with the human resources director, but
yeah, I would start there and say, listen. And I understand you guys may have not intended this a certain way, but I relied on that, and I used up my first 2 weeks. I would have saved time, A, for sick days, and B, to do something else like deer season or something.
Right.
And I don't understand why this is going to be held against me. So I'm asking for is, that additional time. And it's not my fault. You guys clearly gave me a handbook, and I can guarantee you if I had broken one of the new rules in the handbook, you wouldn't have told me it took effect next year. You'd be like, you just broke a rule in the new handbook you signed.
Right.
Right?
Okay. I mean, it's a matter of how much do I like my job, too, But my thing about it is if nobody challenges them on stuff like this
right.
is how employers and everybody gets away with it because nobody challenges them.
On the other hand, if you're the guy who always challenges everything, sometimes they just get rid of you.
Well, that's what I was getting at when I said about how much do I like my job.
The flip side is some employers like an employee who once in a while stands up for themselves because you figure they're also the type of person that might stand up for the company.
Uh-huh.
So, they may not, as long as you're respectful about it and just kind of lay out your case in a very, if you run around and agitate all the other workers, that's one thing. If you just go directly to the boss or human resource and sit down and just say, listen, I'm not going to make a big deal out of it. I won't tell anybody about it, but I want this, and here's why. They may give it to you.
Okay.
All right?
I got you.
All right, brother. Good luck.
All right. Thank you.
540-0580. As you guys know, I have to repeat that number often because sometimes people listening have no idea what number to call. Lewis, you're on the air.
Oh, thank you. I have a question about traffic court. Not that I'm accused of anything, but it was thinking the other day. Say if a police officer accuses you of running a stop sign and you plead not guilty to it, where's the evidence? How can they convict you and say you're guilty if it's just his word against yours?
Because a person's word is considered testimony, and testimony becomes evidence if believed. Okay? So, I mean, here's the question. If a woman comes out of an alley and says a guy in there attacked me, how can it be a crime unless we believe her, right? Because it's her word against his.
Okay.
And when it's a police officer, it's the police officer's word or observations that are going to become the basis of the testimony. And if the judge believes the police officer beyond a reasonable doubt, then you're guilty.
Even though there's no evidence.
But that is evidence.
Okay.
Well, what kind of evidence do you want?
I don't know.
Right. That's what throughout all of human history, throughout all of human history, all we had was the only recording device was the human mind originally. So somebody would come forward and say, this is the guy I saw, and this is what I saw him do. And then somebody else would say, no, I saw something different. So we knew from the beginning those were imperfect ways of gathering information, right?
But that's assuming the person's telling the truth.
But that's why we have all these tests called cross-examination and corroboration, etc. But the word of one witness alone is enough to convict a person. Now, let's come fast forward to this era where there's more and more cameras and there's more and more ways of forensically looking at things, and where science has proven that human memory is fallible, and where science has further proven that witness misidentification is very powerful and problematic in the law as well. We may reach a point someday where you can't be convicted on somebody's word alone. Because we would say, well, there's got to be a camera on every corner, so there should be some footage to corroborate this, or there should be some actual footage of it, or someday everything's going to be recorded all the time.
Okay.
Right?
All right, thanks.
All right, good luck.
All right, bye.
540-0580. What else do I want to remind you guys about? I have my little cheat sheet over here. Of course, remember, 2 o'clock, I got to have, let me see who we got here. We've got Dave Nesbitt, John Reese. They all work together here, and Paula White. And I think they all do different things, so it's kind of like a team that does, let's see, John's their elder care coordinator. Am I getting that right? And Paula, are you elder care coordinator too, or what do you do? Public benefits specialist?
Yes, and legal assistant. So I help with Medicaid and the VA applications.
Okay. We had a VA question last week, and I told them to call back this week, so hopefully they will. And, of course, Dave's the boss.
I don't know about that, but I do my best to fake that one.
So they're gonna be with us now through 3 o'clock. But I'm just gonna have them here in the background, and then we'll switch to an elder law focus at 2 o'clock. But feel free to chime in on any other callers that we get, in case you know better than I do, because I only know half of this stuff.
You do a good job, Carl, and I listen to you when I'm not sitting here.
540-0580 is the talk line number. You can call and get your questions answered. And of course, remember, at 2 o'clock, we're going to switch to an elder law focus and emphasis, and we'll talk about what that is in a minute. September 4th at 7 p.m., Harrisburg Hunters and Anglers, little conversation about gun laws and gun rights. When can you shoot your neighbor for breaking in? And, all those good things. And, of course, that's the problem. When it's your neighbor, it's going to look very bad for you later. Also, you can get a free mug at the Carlisle Bakery. Just stop in. We just gave Dave a nice mug. They're pretty nice mugs, huh?
They are. They really are. I'm going to use this. I can use it in my car or my office. And
just scratch the name off. You'll be fine.
I'll leave it on, Carl.
They're screening somebody right now. We'll put them up here in a second. Also, don't forget you can go to Facebook, and if you Facebook me, of course, you can see all our stuff that we put up live throughout the week on there. And, of course, at RomingerLaw.com if you need to get a hold of us throughout the week. And then I've been told I got to give you guys the phone number as well, because I guess 3 of you still don't have Internet access. It's 241-6070, 241-6070. What do you do? What's he screening for a living over there? Get that guy up there, would you? I can't see him. I don't know who to call for yet. We got a guy in training over there, so he's just getting new at this. Colleen,
Hello.
You're on the air.
Hi, my name is Colleen.
Yep.
I have a question. It's regarding real estate. We had a failed real estate transaction a week or two ago.
Okay.
And what happened was we had an individual come to us. We have property for sale, and we had an individual come to us with a real estate agent, and they said, hey, we want to buy the property, whatever. And we were under the understanding that the buyer's real estate agent is responsible to make sure that the buyer actually has the money to buy the property.
Not really, but okay.
Well, that's my whole question. What happened was we went to the actual, he signed a sales agreement. There was $40,000 involved that was to be paid.
Right.
And then the week or two after, we were to sign the final agreement. He defaulted on the money, of course, because he never had the money. And all along, I was telling my husband, have our attorney call this person's attorney and find out if he really has this money, because this guy is known to be whatever, a shyster, whatever. And because of that, no one ever did that, because my husband believed our real estate agent, who had talked to his real estate agent. She said, hey, I checked on it. He's got the money. Everything's a go.
Now, well, if there's a misrepresentation, that would be different. So did somebody actively misrepresent that the money was there?
Well, the individual certainly did.
Okay. And now my question about...
we know, so did the real estate agent.
What does your contract say if the person can't come up with the money?
Well, I guess he's liable.
Okay, so you can sue him. You can sue him for your contract damages.
Right, but this individual, of course, has no money.
Did you get some hand money?
Pardon me?
Some hand money at the time of the signing? Any money given?
I understood that the contract said he had 3 days to come up with the money, with the down payment. Okay, and that was to be put in escrow, and that was another thing. What happened was the 3 days went by, and we were never even aware that the money was never put into escrow. I guess the buyer's real estate agent was supposed to collect the money and put it in escrow and so forth. And we found out 3 or 4 days after the 3 days was already up that no money ever passed hands and that he was in default.
Well, I'm going to defer to Dave Nesbitt on this one. I think he knows a little bit about this area law.
I do. I'm a real estate broker, and I have 30 years in real estate, although I do not list property now. And I'm glad you did not tell me the name of your broker.
No.
Ideally, your agent, the one working for your broker, it would be that individual's responsibility to make sure that you did receive the escrow payment. That would be your agent's responsibility. Okay. In the best circumstances, your agent should have requested that the buyer's agent produce a letter from a mortgagee, the lender, that would indicate that the buyer had already been approved for a mortgage. That would have been the best way. So if you're going to take another shot at it, and I hope you do, maybe this time you ask your agent, the one listing the property, to make sure that whoever has given you a contract is pre-qualified for a mortgage, and presents a down payment that your agent can deposit into their account at the time of that you agree to the deal.
Okay, so you're basically saying it's not the buyers, it's not. I understood they were bonded and that they were responsible for making sure that the money was there when they bring their buyer in.
The buyer's agent represents the buyer. Your agent represents you. So that's who you should be looking to for responsibility here.
Okay, well, so thank you for your information. I appreciate it.
Yeah, and I think that's kind of why I said, unless there's a squarely fraudulent misrepresentation by the buyer's agent, which would make them party to the buyer's fraud.
I'm assuming that the agents are realtors, and the realtors do have a code of ethics. So if your agent is saying that the buyer's agent behaved in a way that is unethical, then there is a process to grieve the actions of the buyer's agent with the Harrisburg Association of Realtors. But I doubt that that's the case and this under the facts as you described.
Well, see, what happened was, of course, my husband didn't listen to me. I told
well, there you go. There's the first problem. I got to go to break. We're late for break.
Thank you.
All right,
okay,
bye. 540-0580. All right, welcome back. Carl Rominger here. And, of course, I'm going to be joined a little bit by Dave Nesbitt and crew. We're going to go live with the Elder Law segment here from 2 to 3 p.m., so get your elder law questions ready and write this phone number down, 540-0580. Amy, you're on the air.
Hello.
Hi, Amy.
How are you?
Good. What's going on?
This is my question. My husband and I and family were in Florida in June, and when we came home, our home was burglarized.
Okay.
Broke into a safe, broke the hinges, pried the safe right out of the wall.
Okay.
All jewelry was stolen along with $10,000 cash, and most of the jewelry can't be replaced. They were my mother's. State police, we did some investigation. We found out who the kids were who did it. Police report done, and they confessed to us where the jewelry was taken. So the police officers, along with my husband, went to the jewelry store and recovered at that point one watch, which was taken apart.
Right.
And the other pieces of jewelry were sent out to be melted.
Okay.
Now, they did this within 3 days, and there is a Precious Metals Act that says that a jeweler may not do cash for gold until 3 days are up. They must also make a list of items bought along with a photo of the person who did pawn these items.
Well, you know more of the law than I do right now.
I'm sorry?
So you know more law than I do right now, but go ahead. Keep going.
Okay. My question is this. The jeweler evidently absolutely did everything against the law.
Right.
So I have gone to the police station and asked if the jeweler was cited for receiving stolen goods.
Mm-hmm.
And the question was, no, that's not our department. The DA has to cite them. So I went to the DA's office, and they said, oh, no, the police have to cite them.
Right.
So now they're just playing jokes with me. My question is there a suit, something that I can, because I have proof that the
right.
jeweler did go against the law.
Well, that's an interesting question. What we wouldn't know the answer to without researching it is whether that act creates a private right of action or not. So sometimes when the legislature says that a business shall do something a certain way, they reserve it to the attorney general, for instance, to enforce it, or they leave it to some regulatory body to enforce it. So HIPAA, for instance, is not publicly or privately enforceable act, okay? Mm-hmm. On the other hand, if it is privately enforceable, or at least there's some other theory, I mean, I think you probably could sue the jeweler then, at least under some theories that they, I don't say negligent, but they may owe you a duty because they destroyed your items, which somebody didn't have the power to give them title over, and which they didn't take, or at least use the duty of care that the legislature seems to think they should have, which is to hold it for a few days and take a picture and do some other things.
Okay. Well, what the police officer is saying to me, you can't prove he can't prove, or you can't prove that the jeweler stole that the jeweler bought stolen items.
Right. You can't prove that the jeweler knew they were stolen, but the fact that the jeweler moved so quickly to melt them down and otherwise dispose of them would seem to be at least evidentiary of that, or arguably they had no idea what they were doing, which is the other possible explanation. They could plead at trial. The question is whether a jury would find them guilty beyond a reasonable doubt or not.
Well, one of the persons who stole the jewelry wrote a itemized statement for me,
right,
listing what he brought the jeweler.
Well, right, but what I'm asking, so let me give you an example. If I'm the jeweler and a kid shows up with a heroin needle hanging out of his arm and 10 gold doubloons, right? I'm going to go, wait a minute, these might be stolen for drug money. I probably should know that. On the other hand, if a middle-aged woman comes in and says, I'm selling some of my jewelry, and presents me with five rings that look like they belong to a middle-aged woman, I'm not going to be on alert, right?
Well, my question is, the child who brought this jewelry into the jewelry store is 21 years old that walked in with $100,000 worth of jewelry.
Right. So that on its face should be suspicious. So we often say to somebody, if you buy a television out of an alley for $100 that should cost $2,000 at the store, you're on notice that you may be buying stolen merchandise, and you're probably subject to potential prosecution. So, yeah, I would agree with you. You might have an issue. The problem is getting law enforcement to run with the flag.
Exactly. Okay.
All right.
Okay. That's what I thought.
All right.
I appreciate your help.
Take care.
Thank you. Bye.
I mean, I don't know about you, but $100,000 for the jewelry, 21 years old.
Little suspicious.
Little suspicious. All right, guys, when we come back for the next hour, we're going to have our elder law special, 540-0580, 540-0580. Get your elder law questions ready from 2 to 3 p.m.